the result of it is essentially the state's arguments. So we filed our initial brief approximately 6 months ago. Now the state has filed their response. So essentially, it's all of their arguments to the assignments of error that we set forth in our original brief. And then we'll have an opportunity now, or I'll have an opportunity now, to reply to all of the state's arguments in its brief.
Okay, so one of the first things that you mentioned was the instructions to the jury.
Right, and essentially our argument in short was that the jury should not have been instructed on general self-defense instructions. If there's a street fight, for instance, if you are saying that you acted lawfully in response to being assaulted, then you have to use a reasonable amount of force in response to that. And if you're in a home under those instructions, there wouldn't be a change. Our argument is that under the Castle Doctrine or defense of an occupied structure, that's a totally different standard. Essentially, you can respond with deadly force to a threat of any bodily harm in the state of Montana. That's what protects a homeowner against intruders. And, essentially we're arguing that the court should not have given that instruction on self-defense of a person. They should have just instructed on the applicable instructions in a home, because that's the preferential standard that you get if you're in a home and you have a confrontation.
Okay, what was the state's response?
Well, the state's response is essentially that both instructions fully and fairly instructed the jury because of the fact, in part, that Markus had made statements that he feared for his life. And they're saying if he said he feared for his life because of the fact that he was, that evidence was given, that they could instruct the jury that that if he felt like his life was in danger, that he then and only then he could actually respond with deadly force. And our point is that essentially, if you have a threat against someone, or if you're threatened in your home, your response doesn't have to be proportional. That essentially any bodily harm would have been the standard. So they're arguing that both instructions were given, and there was evidence to support that. But in our opinion, Peter, essentially, we're saying that if someone fears for their life, that means that they feared an assault. I mean, the whole point is you get that deferential standard in a home, and the jury should not have been instructed on self-defense in a street fight. Essentially, we're arguing that he was pulled out of his home through the jury instructions, and that shouldn't have happened. Okay.
Now, what about the motion for a change of venue?
So, the motion for a change of venue, there's a couple things that I'd note. One thing that they are arguing is that media coverage would have been the same here as it would have been elsewhere, and this case essentially wasn't that notable with respect to media coverage, which, I very much disagree with that characterization. I have on the record 450 news items just published locally. Some of them were radio, some of them were TV, some of it's the local paper, but the point is I've never seen a case like that with that many articles, but the important point is how many are on the record. And we preserved all of these articles and sent them up to the Supreme Court. So they're essentially saying that he could have he could have received a fair jury trial based on just voir dire and asking the jurors questions, and that they're it's not that remarkable with respect to the media coverage. And I just it's our opinion that there's simply no way with that much media coverage. Again, over 400 local articles, all of which, to some degree, are talking about alleged statements that Markus made or Janelle made, saying that they were going to do what they were going to do, allegedly. And the point is, how are you supposed to just completely dispel that? The primary example of it being the criminal history stuff that wasn't part of the record. It wasn't in the evidence, but it was published on the front page of the paper 2 weeks before trial. And, that stuff's inadmissible. It wasn't even something we had challenged because it wasn't disclosed to us by the state. So,
and because you can't unring that bell, right?
Yeah, absolutely. That you can't unring that bell. That no matter what, even if jurors are trying to be objective, when they walk into that courtroom, with 90% of them, based on our jury, based on the questionnaires that we sent out, 90% of the jurors knew about it. So how then are they supposed to just dispel all this coverage and what we believed at the time to be very, very negative coverage of the case, and extremely prejudicial to Markus, So again, I think that the state always has an advantage here to say, well, they were fully and fairly instructed, or to say that, the jury could have been impartial even with the media coverage. But in this case, it really is extraordinary, and I haven't seen a case like it. And certainly, I don't believe the Supreme Court has addressed a case with nearly as much media. And I think a lot of the cases go back a while. You're looking for volatile situations in the public, but I think you can really see that online now versus what you saw before. Each article then goes to Facebook, it goes to Twitter, and there are hundreds and hundreds and hundreds of comments. One of the first articles had 450 comments, which, in my opinion, that's pretty extraordinary, and I have not seen, at least in my experience, I haven't seen that. So.
Okay. Now, the next one was the juror, the challenges for one prospective juror.
Right, and part of their argument is that certain objections weren't made at the time by us based on specific arguments that we're making on appeal, and you have to make every argument below that you do on appeal. Our position is that we preserve those objections, but essentially they're arguing that the juror we challenged had ultimately said that she could be fair and impartial. Our position is that a juror who's married to a former assistant chief of police in Missoula, as well as someone who knew the lead detective since he was a baby and worked with the lead detective's father, those kind of things should have warranted dismissing her from the jury. We should not have had to use a peremptory challenge. We also had some statements that indicated that she was more inclined to believe law enforcement than the accused, or that she'd treat statements by Mr. Kaarma with she'd be more suspect of those statements than she would be of statements made by police. And ultimately, she said on the record that she could be fair and impartial, but again, it's when someone asks you that, a lot of times it seems like a time when, of course, I can be fair and impartial, but the reality is those ties to law enforcement and your beliefs are hard to dispel when you're trying to be fair and impartial during a jury trial.
Okay. Now, the fourth one, the district court properly admitted evidence of Kaarma's prior assault of Ms. Flager and the testimony of Detective Baker about the victim's blood.
So these are essentially what evidence can be presented to a jury, and certain character evidence was excluded, and those proceedings were sealed. And what the state argued is when Janelle testified that Markus was the home protector and, felt like he needed to protect his family, that by doing that they could then bring in the allegations of prior assaults because he wasn't convicted of that offense. So then they got to ask Markus on the stand, have you ever been, or has Markus ever assaulted you? To which she responded, yes. Our argument is that's prejudicial and that we didn't open the door to admitting that testimony. Now, the interesting thing about this is that testimony, in part, had actually come out on direct because that was actually the state's witness. So our argument is that the state had already brought that up. We expanded on it, and then they used something that they brought out to open the door when we didn't call her as a character witness, which is important because, in a jury trial, you can't have people being tried for prior acts unless they're, relevant to what occurred on the instant crime someone's being tried for. So it can be very harmful to essentially try someone on their bad character, and that's what we're trying to avoid. And in our opinion, we didn't open the door to that, and actually the state did. But moreover, we just don't think that should have been introduced, to rebut the fact that Markus said he was a home protector. It just, in our opinion, it just shouldn't have rose to the level of then being able to bring in previously excluded evidence. Okay.
Now, what about the victim's blood and Detective Baker?
Right. So, there's a lot of stuff that happens in these trials pre-trial. One of the things that gets litigated is, what evidence is going to be admissible with respect to experts' testimony. And our position was that essentially the evidence related to the blood was required expert testimony. That's where they submit a report, they do a lot of testing, and they say, based on this evidence, here's what I see. But Detective Baker wasn't disclosed as an expert to us, and we didn't have that expert report to rely on, so we couldn't get a rebuttal expert. And so when Detective Baker testified to, and again, he's obviously an experienced detective, I understand that, but when he testified to the blood spatter and then reconstructed the scene, we didn't have that evidence. We didn't have an expert to then come in and say, actually, that's not what this blood evidence says. And the point is, you can't not disclose an expert and then try and bring in that testimony through a lay testimony when it required, in our opinion, an actual expert report. Their position is that it was lay testimony, it was appropriate based on his experience. He could testify to that. And so obviously there's a disagreement there, which ultimately the Supreme Court will decide, which way it's going to go on that. So again, that's kind of a summary of the issues.
Okay. So now that you have their response, what happens next, Nate?
Well, I filed my reply brief. We have technically 2 weeks from now to file it, but we'll be requesting an extension, certainly. I would, our hope is to get it done as soon as possible, but we'll probably be requesting between, 30 and 60 days. And now I go through all the state's arguments and rebut them, say, okay, well, this is where we disagree and this is why. And then that's the last briefing that's done to the court. And then the court will decide after we file that whether or not they're going to hear oral arguments on it, how many justices will decide it. And then if we have oral argument, obviously everyone will be aware of that. But then it goes to decision. So this is the last brief that will be filed. And after that, we'll be expecting to move towards a decision from the Supreme Court.